Good morning, everyone. This is Rich from Virginia Beach. It is Saturday, 14 December 2024 at about 10 a.m. when I'm recording this. I'm recording this because back on the 27th of October, I did a drive-in talk, and it was highlighted Fraudulent Property Taxes Explained. And in that video, I told you that I would post updates to my North Carolina property tax suit as things happened and things progressed. So a few things have happened. And what I'm showing you here is the summons that I mentioned on that video. It's a civil summons, alias and pluri summons. I'm not really sure what that means. I never looked up this general statute and this rule. But here's the file number. And the plaintiff is Halifax County. And I am listed as the single defendant. And then it gives my name and my address. And it says a civil action has been commenced against you with big exclamation point. You're notified to appear and answer the complaint of the plaintiff as follows. 1. Serve a copy of your written answer to the complaint upon the plaintiff or plaintiff's attorney within 30 days after you've been served. You may serve your answer by delivering a copy to the plaintiff or by mailing it to the plaintiff's last known address, and file the original of the written answer with the clerk of Superior Court of the county named above. If you fail to answer the complaint, the plaintiff will apply to the court for the relief demanded in the complaint. And M. Glenn Rollins is the guy I mentioned in my video. He's the Halifax County attorney. He is the guy that actually filed this. And Leanne Phillips is the assistant Superior Court clerk. But you notice that there's no endorsement because it was never, there's not a return of service because they can't verify that I ever received this. They sent it certified mail and I never sent the receipt back. So they can't definitively say that I even received this. So this is a bogus summons that you can file on a legal entity, but you cannot file on one of the people. If one of the people are protected by the due process of law, and part of that is proper service, which means a human being approaches you wherever you are, wherever they can find you, and they ask your name, and you tell them your name, and they say, I have some paperwork for you, and they give you the summons and they give you the complaint. They said, here's your summons, here's your complaint, you've been served. And then they take this return of service and they file it with the court. The date served, the time, the name of the defendant, and you put down here what you did. Or you put the name and address of the person you left it with. Or if you did another manner of service. Or defendant was not served and give whatever reason. There's obviously only one defendant, so they can't fill this out because they mailed it. So that's the problem that they have with this. So that is the undelivered summons. And here is the complaint that they were nice enough to file. So it is from the County of Halifax, State of North Carolina. Here's the file number in Halifax County versus me, the defendant. And they're making some claims in this complaint. And the first one is that the plaintiff is a body politic incorporate under the general statutes of North Carolina that has the power and authority to assess, levy, and collect taxes against real and personal property located within its boundaries in accordance with the laws of North Carolina, which is absolutely true. They can do that. There are taxable entities within their borders, and there are specific ways they're required to do that. This is a tax lien foreclosure action brought under this general statute, and I'm going to show you right after this my motion to set aside. I've read this entire general statute. against a certain tract of real property described below, hereinafter the property. As such, this is an action for judgment in rem that will affect the title to the property. So it won't affect the ownership, but it'll just affect the title. You notice how they put that in there. This is not an action for a money judgment, which is a false statement. And this very complaint will back that up. This is not an action for a money judgment or for judgment for court costs against the defendant personally. Okay, well, we'll see how that pans out. Upon information and belief, myself is unmarried, is a resident of Virginia Beach, is sui juris, and is not an active member of the military. I'm not even sure what sui juris means, to be honest with you. It may have something to do with unrepresented. I don't know. But the rest is true. So this is pretty much boilerplate stuff, first three things. The fourth thing, the defendant, myself, duly listed the property for taxes for the years 2019 through 2024, which is an incorrect statement. Or the property was lawfully listed for taxation for those years on behalf of said defendant or his predecessor in title, which is also not true. You see how they just make presumptions and assumptions? We'll go through this and they don't back it up anywhere. It's just a statement that they pulled out of their butts. Pursuant to these general statutes, the unpaid property taxes constitute a first lien against the property. Well, it actually doesn't. The current amount of the tax lien, including interest hereon, as computed under the provisions of these statutes for the years indicated, is set out below, following the tax parcel number, address, and legal description of the property. I don't know how they can get a tax parcel number because I bought this property in 2009. I paid property taxes on it from 2009 all the way up to 2019. So for 10 years I paid property taxes on it because I didn't know how property taxes were supposed to be done. We all think that we owe property taxes simply just for owning property, and that is just not true. As I've explained in the other video, there has to be very specific provisions, and business owners know when you list your stuff for taxation, you have to be pretty precise. You do your own assessment, and you turn it in every year for the property you use with that business to earn your income. So your income is taxed, and your property that you use to earn that income is also taxed. And there has to be records for this stuff. They can't just divvy out a tax parcel number and voila, your property is automatically taxable. Well, that's not how it's supposed to work, but that's what they do. They even gave it a tax parcel property number. Where that number came from probably came out of one of their databases. Address of the property, Hummingbird Lane, Littleton, North Carolina. That is true. There is nothing on that property other than trees. And they give a description of the property, which is at Lake Gaston. And here's where it is recorded in the title book, and it is conveyed to me by a deed of Tom Charnetsky and wife Sherry Charnetsky, dated September 2nd, 2009, recorded in book 22393, page 4, Halifax Public Registry. Reference to said map and deed is hereby made for greater certainty of description. And that's all that typically means. That's called meets and bounds. That's how property is supposed to be listed on a deed. It is supposed to be by meets and bounds. And all of this is meets and bounds. That's what that means. So here are the years they're claiming that I owe taxes, which I did not pay. And they add up to $919.61. Now that's a pretty important number because they're going to be asking for a whole lot more than that, which they're claiming up here that they're not asking for. This is not an action for a money judgment, but you're going to find out that they do ask for it. Taxes for subsequent years may accrue or come due on the property before the termination of this action. And it's saying that they're also going to apply. If payment of taxes is tendered before the judgment of sale is confirmed, defendants are given notice, there's only one defendant, are given notice that this action will not be dismissed unless and until all costs of this action are paid. Cost of this action. What do you think the costs of this action are? We'll get into that. And include plaintiff's attorney's fee. The attorneys always want to make sure that they get paid. That is the only thing these shysters care about, is that they get paid. If desired, defendant has the right to request a hearing on the amount of plaintiff attorney's fees. I don't care about the attorney's fees. They're never going to be paid. This whole thing is going to go away. Wherefore, the plaintiff prays the court as follows. 1, the judgment of sale be entered pursuant to this general statute, which I looked up. It's an interesting statute, granting judgment in rem against the property, not against me, against the property, described in this complaint for the amount of unpaid taxes and interest as set out above, plus any subsequently accruing taxes and penalties, interest and costs thereon, as allowed by law, and the cost of this action. And the cost of this action. They want to make sure they're getting paid. And that said judgment declared a first lien upon the property. That the shyster be appointed as commissioner to sell the property, after due advertisement in accordance with law and under the direction of this court, and to deliver the purchaser at sale a deed to said property, in fee simple, free and clear of all encumbrances. They're saying there's an encumbrance on it now, but they're going to deliver a deed that's free and clear of all encumbrances, which a tax is considered an encumbrance. So they're going to take it from, they think they're going to take it from a guy who there is no taxable activity occurring on that property. There's never been. I've never listed it for taxation, yet somehow it shows up on their tax roll. But they're going to convey a new deed of the property to some clown who thinks they're going to buy my property, and it's going to be clear of all taxable encumbrances. It's unbelievable what these people think they're doing. Shall be forever barred and foreclosed. So they're going to steal it from me, sell it to somebody else, pay themselves handsomely in the process, and all of this is without even a judge looking at it. And I'll explain that a little bit later. And 3, that the commissioner be ordered, which is now going to be this shyster up here. He wants to be the commissioner. So now he be ordered to pay from the proceeds of the sale of the property the taxes, penalties, interest, and the costs due the plaintiff, which is also the commissioner. He wants to make sure he gets paid, together with the cost of this action, and to pay the surplus, if any. Oh, they're going to give the surplus to the clerk for benefit of the persons entitled thereto. Well, who do you think the persons entitled thereto are? That would be me. With the further provision that the clerk hold any surplus until rights thereto are established in a separate special proceeding pursuant to this general statute, which I never looked this up. I don't need to. And with the further provision that neither the commissioner nor the plaintiff, which are both the same, shall have any obligation to bring such special proceeding. So they don't even have to bring that special proceeding to decide who gets the money. It just goes to the clerk. Okay, 4, that the plaintiff, which is also wanting to be the commissioner, be awarded attorney's fees in the amount of $1,500. Now, the judgment's supposedly only $919, and yet this stick wants to get $1,500 for his efforts to steal my property. This is what I'm talking about, attorneys. This is why I cannot freaking stand attorneys. This is what these people do. What if I had a house on this property? What if my family was living on this property? They would not care. They would try to come in, kick me out and my family, put me out on the street, sell my home, keep the money, turn it over to the clerk, and pay themselves to do it. I don't know how this guy can sleep at night. I really don't understand how these people can think that doing something like this to the people is okay. 5, that pursuant to this general statute, which I've never read, I don't need to, the judgment sale be indexed only as a judgment affecting title to real property and not as a judgment requiring in whole or in part the payment of money or the payment of court costs by the defendant or the defendant lien holder. I don't know how they can make such a statement. They just asked for all of this stuff. $919 plus, this be paid and whatever else they can conjure up also has to come out of the judgment of sale. And this judgment of sale is an interesting term too. I haven't looked that up, but I just might do that. And then they have a verification. And Doris B. Hawkins, I mentioned her. She's the one claiming that I owe the taxes. She's the assessor and the collector, both. I know it doesn't say assessor on here, but that is her official title in Halifax County, North Carolina. The undersigned, being duly sworn, deposes and says that she is the tax collector for the plaintiff taxing unit in the above entitled action, that she has read the foregoing complaint and knows the contents thereof, and that the same is true to her own knowledge. Well, I've been asking for the last 5 years for the documents that I actually registered my property for taxation, and no documents have been provided. They blow me off every time. Ever since I stopped paying those extortion fees they send me every year, and I started sending them records requests as soon as I figured all this out, they've never sent me a single record, not once. And North Carolina has a law that regulates how they're supposed to do all that. There's not a whole lot of teeth in it. There's no penalties listed in it. So I would have to bring an action to these clowns for not doing what they're supposed to be doing. The government is supposed to be transparent. And one of the ways that the people demand that they be transparent is that when we ask for stuff, we better be getting it. And if it's a large amount of documents, okay, pay a little bit of a fee for it, cover the expense of gathering and producing and delivering all of those documents. I get that. That's okay. But if it's only 1 or 2 pieces of paper, it's supposed to be free. Well, but that all of this is true of her own knowledge, except to matters herein stated to be alleged on information and belief. Look at that. Except to matters herein stated to be alleged on information and belief. Well, isn't all of this stuff up here? Upon information and belief that I am unmarried, am a resident of Virginia Beach, sui juris, and not an active member of the military. So that's the only thing put up here that's on information and belief. They're saying this is a statement of fact. The defendant, myself, duly listed the property for taxes for the years they're claiming. Or that the property was lawfully listed for taxation for those years on my behalf. Which that was never done either. The property has only ever been listed in my name only. I have no representative. I do all of my own work. So this whole thing is just, even the verification. Except to matters herein stated to be alleged on information and belief. As to those matters, she believes them to be true also. But she doesn't have knowledge that I'm single and not an active member of the military. So but she believes they're true. It's just amazing how mealy this stuff is. So I went ahead and I read, let's go back up here. I read this entire statute, 105-374. That's what they're moving under. So that's the first one I read. Tax lien foreclosure action brought under that statute. So believe you me, I read that statute from beginning to end. And there is a very interesting little segment in there, and I'll get into that. But here is my motion to set aside that I filed on, I've got the green card, filed it to the clerk of court. Where'd I put it? Here it is. It was received October 15th, 2024, because I sent it registered mail. So I made this up. I use an iMac, so I use Pages instead of Word to make this up. And then I just turn it into a PDF so everybody can read it. And I've redacted it. I've already took all of my personal information off. But here's the file number that I got from the civil complaint. Halifax County versus me, alleged defendant. Now, this is a motion to set aside because I read this whole thing right here. And part of that, at the very end of that whole statute, it says if any of this, and I'll show that instead of me talking about it, it'll come up. And I call myself the alleged defendant throughout this entire document because I am not really a defendant. I was never properly served. So if I go taking on that moniker of defendant, then I'm admitting that I am a defendant, when in fact I'm not. The alleged defendant comes by special appearance, does not waive any right, including the right to due process of law, which has not been perfected. The alleged defendant only responds to improper complaint to thwart Halifax County, North Carolina, of theft of alleged defendant's private property using an ex parte court clerk action to move forward with a sheriff's sale via statutes designed to act upon legal entities only, regulating inherent rights of the people to a mere absent, distant thought. The alleged defendant averrs the following. The alleged defendant is not a legal entity, and the reason I said that was because of on the very complaint itself, it says that they are a body politic, which means they are a legal entity. I'm saying I'm not, but one of the people as denoted in the North Carolina Constitution, Article 1. Although alleged defendant is not of North Carolina, nor has alleged defendant ever resided in North Carolina, there exists no evidence or statements of facts listed in the complaint that alleged defendant is a resident of North Carolina or a legal entity having duties. Therefore, this matter must be set aside in its entirety as an operation of law and as the pursuit of justice requires. Now, I put that in almost all of my statements, so I'm not going to repeat it every time, but I think it's important for them to read it. 2. The plaintiff in this case is a body politic as stated in the complaint, therefore constrained and restrained in its authority per the North Carolina Constitution, Article 1, Section 1, to take this foreclosure action. And I quoted what the actual thing says, the equality and rights of persons. I don't like the way they use persons, but they're meaning that in the people context, not in a statutory context. We hold it to be self-evident that all persons are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, the enjoyment of the fruits of their own labor, and the pursuit of happiness. The enjoyment of the fruits of their own labor. So you might ask yourself, what are the fruits of your labor? Well, they're everything that you acquire. We have the right to acquire everything we can. That would be the fruits of our labor. Being that the plaintiff is clearly acting beyond its very limited authority granted by the people to the county of Halifax, there is no evidence or statements of facts in the complaint that the alleged defendant has no right to the enjoyment of the fruits of his own labor. Therefore, this matter must be set aside in its entirety as an operation of law and as all that. 3. Being that the plaintiff is a body politic, it is also constrained by the North Carolina Constitution, Article 1, Section 8, that the people of this state shall not be taxed, or, it's not and, it's or, made subject to the payment of any impost or duty without the consent of themselves or their representatives in the General Assembly freely given. Impost or duty, well, that has to do with importation and exportation of goods. And they have to consent to it. And, or, it says, or duty without the consent of themselves or their representatives in the General Assembly. I don't have any representatives in the North Carolina General Assembly. I don't vote for them. They don't speak for me. Nothing. So this could actually be, I could probably move this whole case into federal district court right here in my area because there is a jurisdictional issue here. Because I don't live in North Carolina. I've never, ever lived in North Carolina. Being that the plaintiff is clearly acting beyond the very limited authority granted by the people to restrict the power of taxation upon the people, therefore this foreclosure matter must be set aside in its entirety as an operation of law and as a pursuit of justice requires. Number 4. The alleged defendant in this case would like the court to take judicial notice that the property listed on the complaint and currently being taxed and attempted to be foreclosed is and has been taxed in error. A right of the people to own and enjoy the fruits of their own labor, which is the property at issue, cannot be taxed for exercising those rights. The foreclosure action Halifax County, North Carolina is attempting to apply does not conform within the very specific limits of the constitutional provisions and statutory limits stated above and herein. Therefore, this entire foreclosure matter must be set aside in its entirety as an operation of law and as a pursuit of justice requires. The current action being brought on the alleged defendant and his property is moved in accordance with the North Carolina General Statute, Section 105, Subchapter 2, Article 11, Section 105-273. Definitions. The alleged defendant would like the court to take judicial notice as these definitions apply throughout this entire matter and this motion to set aside. The following definitions apply in Subchapter 2 in its entirety, which is actually stated in the statute. Person, an individual, a trustee, an executor, an administrator, another fiduciary, a corporation, a limited liability company, an unincorporated association, a partnership, a sole proprietorship, a company, a firm, or another legal entities. These are all legal entities, emphasis added. So what is a person? A person is a legal entity because the statutes cannot regulate the people. They can only regulate that which they create, which are all of these things. They create all of these things. Those are the things they can regulate. You notice people aren't listed on there. And don't get it twisted saying an individual is a human being. It's not. They're all legal entities. There can be an individual trustee. There can be an individual executor. There could be many. There could be many trustees. So what they mean by an individual is an individual of one of these. So that's why you have to really know how to read statutes. A layperson might just read this and think, oh, that's them. But what they don't get, another legal entity, meaning all of these are legal entities. Here's another one. Taxpayer. A person, what did we say a person is? Is a legal entity. This stuff all ties together. So we could say a taxpayer is a legal entity whose property is subject to ad valorem property taxation by any county or municipality and any person who, under the terms of this subchapter, has a duty to list property for taxation. Well, as I've already described to you, I have never listed my property for taxation. Yet I have a duty. Has a duty. People don't have duties. Legal entities have duties because they're created by the very government that is taxing them. So I wanted to get those two out up front before I started going on this thing. Number 6, the current tax foreclosure action is being brought by and under the authority of North Carolina General Statute, Section 105, Subchapter 2. The definitions are to be strictly interpreted and applied throughout to only apply to legal entities having duties, which are created under the authority of the North Carolina General Assembly. There exists no evidence or statements of facts listed in the complaint that alleged defendant is a legal entity created by North Carolina General Assembly having duties. The complaint provides no evidence or statements of facts that the alleged defendant is not one of the people enjoying rights protected under North Carolina Constitution, Article 1. For these reasons and others, wherefore this foreclosure matter must be set aside in its entirety as an operation of law and as a pursuit of justice requires. Number 7. Referring to North Carolina General Statute, subsection 105, subchapter 2, article 12, 105-274A2, property, which I stated here, property subject to taxation. The alleged defendant would like the court to take special judicial notice of the following. A, and this is what I'm quoting, all property, real and personal, within the jurisdiction of the state shall be subject to taxation unless it is, and there are more, 2, exempted from taxation by the Constitution or by a statute of statewide application enacted under the authority granted the General Assembly by Article 5, subsection 2, 3, the North Carolina Constitution. This foreclosure action must be set aside from the very nature of the intent of the North Carolina General Assembly via the very statute listed above, referring to point 3, which is point 3 is up here, point 3 right here. Point 3 of this motion, with which this entire foreclosure action is founded, being that there are no statements of facts or evidence presented in the complaint that overcomes the exception carved out by the Constitution and General Assembly in the instant case. Therefore, this matter must be set aside in its entirety as an operation of law and as the pursuit of justice requires. Number 8. Referring to North Carolina General Statute, Section 105, Subchapter 2, Article 14, Section 105-285, date as of which property is to be listed and appraised. The alleged defendant would like the court to take judicial notice of the following. A, annual listing required. All property subject to ad valorem taxation shall be listed annually. That's what it says. Shall. That means you must do it. It is not a choice. It is not an option. They have to. The alleged defendant in this case has never listed his property, his private property, for any tax year. There exists no statements of facts or evidence in the complaint showing or indicating that the owner, which is me, of the property in this case, properly listed the property for tax years claimed for there to exist a valid tax claim. Therefore, this tax foreclosure matter is moot and must be set aside in its entirety. Number 9. Referring to North Carolina General Statute, Section 105, Subchapter 2, Article 17, Section 105-306, in whose name personal property is to be listed. That's what it says. The alleged defendant would like the court to take judicial notice of the following. This is what it says. Taxable personal property, notice it says taxable. Taxable personal property shall be, there's that word again, shall, you see it twice, shall be listed in the name of the owner on the day as of which property is to be listed for taxation. And it shall be the duty of the owner to list the property. Well, I am the owner. The alleged defendant in this foreclosure case has never listed his property for taxation. There exists no statements of facts or evidence in the complaint that the owner, which is me, listed his property for taxation, which is required for lawful tax obligations to exist for the tax years claimed. Therefore, making this entire matter moot, requiring it to be set aside in its entirety. Do you see what I'm getting at? Every one of these is a game stopper. And I'm just throwing a bunch of them at them. Each one taken on its own account is enough to just set this whole matter aside and just make it stop. Number 10, referring to North Carolina General Statute, Section, Subchapter, Article, duty to list, penalty for failure. Alleged defendant would like the court to take judicial notice of the following. And this is what it says in the statute. Every person, there's that word again, which is, we'll say what it is. Every legal entity in whose name any property is to be listed under the terms of this subchapter shall, there's that word again, shall list the property with the assessor within the time allowed by law on an abstract, setting forth the information required by this subchapter. I'm required to make certain information available. If I am what? If I am a person, i.e. legal entity, created under the statutes, I would be required to do this. How many of you people out there that don't have a business on your property actually fill out something like this? People living in North Carolina. Do you fill out an abstract with specific information that's required by this subchapter? In addition to all other penalties described by law, any person whose duty it is to list any property who willfully fails or refuses to list the same within the time prescribed, you got to do it within a certain time. Shall, there's that word again, shall, it means is mandatorily be guilty of a Class 2 misdemeanor. The failure to list shall be prima facie evidence that the failure was willful. Very interesting part of that statute. The alleged defendant in this foreclosure case has never listed his property for taxation on an abstract. There exists no statements of facts or evidence provided in the complaint that the owner listed his property on an abstract, which is required for lawful tax obligations to exist for the tax years claimed, therefore making this entire matter moot, requiring it to be set aside in its entirety as an operation of law. There exists no statements of facts or evidence provided in the complaint that charges of a misdemeanor have been filed or are pending, which is the penalty for a legal entity not listing on an abstract. That's pretty self-evident. Legal entities are required to do what their creator tells them to do. That's how this works. 11. Referring to North Carolina General Statute, Section 105, Subchapter 2, Article 17, 105-309, what the abstract shall contain. The alleged defendant would like the court to take special notice of the following. Judicial notice of the following, Each person, there it is again, whose duty it is to list property for taxation shall file each year with the assessor a tax list or abstract showing as of the date prescribed by that statute the information required by this section, subject to the provisions of these subdivisions. Each person whose duty it is to list property for taxation shall file a separate abstract. Is this starting to make sense? The alleged defendant in this case has never filed a tax list or abstract with the assessor. There exists no statements of facts or evidence included in the complaint that the owner, which is me, filed a tax list or abstract with the assessor, which is required for lawful tax obligations to exist for the tax years claimed, therefore rendering this entire foreclosure matter moot, requiring that it must be set aside in its entirety as an operation of law and pursuit of justice requires. Number 12. And you can get the same thing. Anytime somebody comes after you about anything, they're going to list a statute. And that's when you need to be digging into those statutes and read them, because you're going to find out they don't apply to most people. They just don't. Unless you're engaged in some kind of activity that this would apply to, like you get some sort of a license or you get some kind of a other privilege that the state grants to you, then you will fall under some of these requirements. You have to be very careful in which ones apply to you and which ones don't. And you're going to find that most of the stuff coming against you, including all the traffic stuff, all the income tax stuff, all the property stuff, all of that is by statute. And most of us, it doesn't apply to. It does apply to certain individuals. You have to be cognizant whether or not it's applicable to your activity. You don't want to be held responsible for this stuff when you shouldn't be. That's called misapplying. Except as otherwise provided in this section, the person whose duty it is to list property for taxation shall file the completed abstract with the assessor for purposes of listing and shall sign the affirmation required by this general statute to be annexed to the completed abstract on which the property is listed. The abstract must, there's that word, must and shall, must be filed with the assessor on a form approved by the Department of Revenue. So you can't just fill out any old form. It's got to be on a specific form. It has to be signed with the owner's signature. It has to be on a form approved by the Department of Revenue. It has to be done within a certain time frame. There are a lot of requirements on taxable entities. I've never done any of this stuff concerning my property, ever. In the case of an individual taxpayer, remember what the definition of taxpayer is. You notice they throw that in there. Go back up and look what the definition of a taxpayer is. It's not me. In the case of an individual taxpayer who is unable to list his property, a guardian, authorized agent, or other person. A guardian, an agent, all of those can be persons. Having knowledge of and charged with the care of the person and property of the taxpayer, shall file the completed abstract and shall sign the required affirmation in the name of the taxpayer, nothing here noting thereon the capacity in which he signs. So it has to be done. Whether or not you can physically or mentally do it is irrelevant. You can have a guardian or an authorized agent or other person having knowledge and charged with the care of that person and property shall file the completed abstract. So they're going to get theirs no matter what. The alleged defendant in this foreclosure case has never signed an affirmation or filed one with the assessor. There exists no statements of facts or evidence included in the complaint that the owner, which is me, is a taxpayer, has signed an affirmation or filed one with the assessor, which is required for lawful tax obligations to exist for the tax years claimed, therefore making this entire foreclosure matter moot, requiring it must be set aside in its entirety as an operation of law and as the pursuit of justice requires. This action is listed as being brought under North Carolina General Statute, Section 105, Subchapter 2, Article 26, Section 105, 374, which is entitled Foreclosure of Tax Lien by Action in Nature of Action to Foreclose a Mortgage, which I've never had a mortgage on this property. So, is it really applicable? I don't know. Let's keep reading. The alleged defendant would like the court to take judicial notice of the following, which is C. C. Parties summons. Each of the following persons shall be made parties and shall be served with a summons in the manner provided by this rule. The owner of record and the owner's spouse, if any. All other taxing units having tax liens. All other lien holders of records. And 4, all persons that would be entitled to be made parties to a court action to foreclose a mortgage on the property in which no deficiency judgment is sought. A trustee in a deed of trust shall not be made party and shall not be served. Pretty interesting little, pretty interesting. This whole thing is pretty interesting. So, I say, no evidence or statement of facts exists within the complaint that state the alleged defendant is a person or taxpayer to which only those legal entities could be a party to this action under the authority of North Carolina General Statute, Section 105, Subchapter 2, Article 26, Section 105, 374. There is no evidence or statements of facts within the complaint that the alleged defendant is not one of the people holding sacred rights inherent to the people, which would prevent a foreclosure action such as this. Therefore, this matter must be set aside in its entirety as an operation of law and as of the pursuit of justice requires. 14. The alleged defendant has communicated with the plaintiff several times via email. When I say plaintiff, I'm talking about Doris Hawkins, who is the tax collector. I'm talking about M. Glenn Rollins. There's another guy called Lynch there. There's a bunch of people that work there that I've been in communication with for almost 5 years now. I was in communication with them before I stopped paying my taxes. When I first realized what a fraud this actually is. And then I tried to communicate with them, and it'll explain some of the goings on that happened during that communication. Plaintiff several times via email, certified mail, email, and fax for the last 4 years, which is the same time frame of claim taxes due, asking for records that must be on file in order for plaintiff to claim a lawful tax liability exists for property listed in the complaint. The plaintiff, which means Halifax County, has failed at every opportunity and in every instance to produce any documentation required to be on file with alleged defendant's signature as required to substantiate any of plaintiff's tax foreclosure claims. The claimant provides no evidence or statements of facts that these documents exist as they must to be a valid tax claim. Therefore, this entire foreclosure matter, including fraudulent sheriff sale, advertisement of sale, threats of wage garnishment, foreclosure, preposterous, exorbitant attorney fees, penalties, and interest thereof, must be set aside in its entirety as an operation of law and as a pursuit of justice requires. $1,500 attorney fee he wants for that, for making that complaint and filing it with the court. He wants $1,500. That's ridiculous. Completely. That's telling you. That's why I go spare no effort in taking it to these attorneys and showing them their ass every time. 15. Plaintiff informed alleged defendant years ago, which was me, when alleged defendant requested required tax documents. And I'm paraphrasing, but he actually sent me a letter. It's either an email or a letter, I forget which it is, but I still have it. My client, this is what he said when I was asking him for these documents, and I even showed him the statutes that demand he does it. My client is the County of Halifax, North Carolina. May I suggest you retain your own counsel? There will be no further communication on these matters from this office. That's what this shyster told me one time. This is how they treat the people that they work for. This is how they treat their masters. Alleged defendant has exhausted every good faith effort known then to him to communicate the grievous errors being made on behalf of plaintiff in the matter of misapplied tax statutes. These communications fell on deaf ears. Therefore, the matter must be set aside in its entirety. Alleged defendant acted in good faith, conforming to the doctrine of clean hands and in the pursuit of fairness, good faith, equity, and justice. With all the matters of law and within the strict interpretations observed above, there exists no evidence or statements of facts within the complaint that the alleged defendant can answer. The alleged defendant cannot answer presumptions or assumptions where no evidence or statements of facts exist. This entire action is beyond the very specific and limited authority of the taxing district. Therefore, this matter must be set aside in its entirety as an operation of law and as a pursuit of justice requires, in accordance with North Carolina General Statute, Section 105, Subchapter 2, Article 26, Section 105-374, 5F. Alleged defendant requires removal of subject property from all tax rolls and all obligations in Halifax County, North Carolina, until such time as the property or owner thereof obtains a taxable situs or situs. The alleged defendant requires remittance of paid property tax assessments from the County of Halifax, North Carolina, as is on file for tax years 2009 to 2019, as required by North Carolina General Statute, Section 105, Subchapter 2, Article 27, 318. An unlawful tax paid from its fraudulent application is due to be refunded. Alleged defendant requires remittance, it should be of interest for paid property tax for tax years 2009 to 2019 at the rate of 6% per annum, plus cost as required by North Carolina General Statute 105-381D, which that's where I got that 6% per annum. That's from the date that they were paid. Going all the way back to 2009, that's going to cost them some money. Alleged defendant requires compensation in the amount of $20,000 for grievances, threats, harassment, and lack of response for tax documents requested by alleged defendant and the movement of this fraudulent foreclosure action by plaintiff on alleged defendant, costing alleged defendant countless hours of research into the codes and constitution of the foreign county of Halifax, North Carolina, cost of printing, signing, travel, phone calls, fax, unanswered records requests, postage, and miscellaneous supplies. I think that's reasonable. My time is very valuable. Alleged defendant requires a sincere apology from plaintiff and all public servants involved in this fraudulently applied tax assessment, collection, foreclosure action, infringing upon alleged defendant's unalienable right to procure, own, protect, and enjoy the fruits of his own labor per North Carolina Constitution, Article 1. Alleged defendant asks for such and other further relief as the court may deem just and proper. And I got that from the very complaint. He had a little blurb in his that said that too, but I made it a bullet point. They have to answer every one of these. When they look at this, they're going to have to overcome all 21 of these. Why it should not be, this motion should not be granted. By the alleged defendant's hand on the 7th day of October, the alleged defendant swears that the information contained in this motion to set aside is known to him to be true, accurate, and correct to the best of alleged defendant's ability. Meaning I know all of this to be true, accurate, and correct. It is known to me to be true. This is not on belief. They're going to have to overcome that. And then I signed it as alleged defendant. I gave my full name, my address, my email, and my phone number. So what we're going to do is a few days ago, actually called the courthouse because, I signed it on the 7th and I mailed it out and I got the green card on the 15th of October. Somehow, I don't know why it took them 2 days or 2 weeks to receive it. No, actually it's only a week. So, yeah. So about a week later, I got the receipt. So they've been sitting on this since 15 October. So I wanted to call the court to find out, where are we at? You guys have had this thing forever. This is a motion. What the hell's going on here? So here is that phone call. This is a phone call I made on 12 December to the clerk of the court. I am waiting on a phone call from Leanne from the North Carolina Superior Court, Halifax County, North Carolina, Superior Court Division Clerk. Her name is Leanne. Today is 12 December 2024 at 11:03 a.m. All right, now it's 1:30. I still haven't heard anything back from them. I'm going to call them back.
Good afternoon, Halifax County Clerk's Office. May I help you?
Yes, I'm trying to get a hold of the civil court clerk.
Okay, hold on just a moment, please.
Thank you.
Halifax County Clerk's Office, may I help you?
Yes, I'm trying to get a hold of the civil court clerk.
I do not have anyone available. Can I take a message?
Well, I've already done that a couple hours ago, and nobody called me back. I'm trying to get a status on a case number.
Okay, I'm not sure. I'm sure somebody took a message. They gave it to her. I think she's by herself, and I just came in a little bit ago.
Okay, I want you to listen how these agents treat one of the people. Now, these are public servants. I want you guys to keep this in mind. And look how this lady obfuscates everything. Her name is Leanne. And I want you to remember something here. It's this lady right here. This is the one we're listening to. So she's involved in all this. And listen how she behaves.
I'm not sure. I'll be glad to. What kind of civil case is it?
It's a forfeiture case?
Okay, you said a forfeiture?
Yes.
A bond forfeiture?
Tax forfeiture.
Okay. Yeah,
She knows what I'm
I
talking
don't know
about.
where she is. All I can do is take a message and make sure she gets it and see if she can call you back if you want to leave your information with me.
Yeah, I did that a couple hours ago. And that's why I'm calling back.
She may just not have had a chance to call you, so I'm sorry.
Oh, I'm not casting any blame here. I'm just trying to get some information, and apparently nobody's able to help me.
Well, there are just certain divisions, and not everybody has the access to the same stuff, so that's why, I mean, it's not that, we don't want to help you, it's that, not everybody can look at certain things,
Right.
It's not that they can't help me, it's that they don't want to, because they know what this is about. I guarantee these people have already read this motion. It's been 87 calendar days since they received my motion to set aside this entire action. I guarantee you the plaintiff has already read it, the clerk has already read it, she has read it, and they're wondering what to do. They don't know what to do.
I get it. I totally understand. That's why I keep calling back, because nobody ever gets back to me.
Well, what is it that you're trying to figure out?
I'm just trying to figure out a case status on a case number that I have and find out where this is at and where. That's all I really want to know.
What's the case number?
The case number is 24 CVD 721.
Hold on just a minute.
Thank you.
This is Leanne. Can I help you?
Hi, Leanne. This is Richard Sowers. How are you doing?
I'm good.
I was just calling to ask about the status of a case number.
Okay. Was it the 24 CPD 721?
Yes, ma'am.
Okay. So it's still open on our end.
What's that mean?
Nothing's been done with it.
There's not been a ruling on the motion to set aside?
No.
Because that was sent in 87 calendar days ago.
Yeah, we received it in October.
Right. There's been nothing done with it?
No. The clerk didn't hear it, and she actually just retired the end of November. So we have a new clerk now.
And
Listen to these excuses.
might I ask what is going on with it?
I mean, did you want to be present for that motion?
Do I need to be?
I mean, that's up to you. That's what I'm asking. Is that something that you want to be present for?
No, I'd actually like to have the results of that hearing.
Okay, I'm going to let you speak to the new clerk. Hang on one moment.
Thank you. Oh, here we go.
Mrs. Sars?
Yes.
Okay. So I tried to speak to the new clerk. She's going into a meeting with our Superior Court judge. She wanted me to get your phone number. She is going to check with the legal, and then she will call you back.
Check with legal. What does that mean?
to see, the county attorney is the one who filed this.
Yes, I understand.
So they have to, they have to be a part of the motion to set aside as well.
Actually, they don't.
Well, I'm gonna take your number and I'm gonna let her call you back.
Okay, who is the new clerk, if you don't mind my asking?
Her name is Lisa Turner.
Turner?
Yes, that's right.
Okay. Are you still the assistant superior court clerk?
I am.
And you're still the one that has signed on this summons and all of that. So you're an integral part of this. So I figured you could give me some information.
So what I can tell you is when they file something, I cannot refuse a filing. I have to issue the summons and I have to send it out.
Now she's going to tell me what her job is, but she isn't going to tell me why she isn't going to do anything in this case.
I understand that.
So I'm not allowed to turn away a filing, whether it's right or wrong. That's not for me to decide. It's for the judge,
The question was not, did you file it? She already told me it was filed. It was filed on the 15th of October. That's not my question.
to decide. It's not for me. So I can't refuse a filing.
So
that is part of my job, is issuing the summons.
Can you give me the name of the judge involved in this case? Because as far as I know, there is none.
There's not one.
Yeah, this is strictly a clerk matter, is it not?
Right. And like I said, the previous clerk that you spoke with has retired. So we have a new clerk that just started a week ago.
Well, actually, the one I spoke with prior was you.
I'm not the clerk of court. I'm just the assistant clerk.
I know,
I
but
don't make those decisions.
you're the last person I spoke to, and your name's on this document.
No, you spoke to Becky Spraggins, the actual clerk of court.
Well, the first time
She told you to send in your motion, and she would take a look at it.
And that's exactly what I did.
Right, and she retired. she has retired and left, and the new clerk has stepped in.
Okay.
So that clerk will be the one that you will talk with.
And that's Lisa Turner?
That's Lisa Turner.
Just out of curiosity, can I expect to receive information from whatever ruling is ruled on this motion? Because
Absolutely.
it's been almost 3 months and I haven't received anything.
Right, and that's because the other clerk, she left.
So how long can I expect this to just be hanging in the balance?
So that I'm not sure. Like I said, this new clerk just stepped in a week ago, and I had brought this to her attention. She told me to get your name and number, and she would call you back.
Well, let me ask you this. Have you actually read my motion to set aside?
I have not, because I don't make any rulings or any judgments. I just put it in the computer.
Has there been anybody that's read my motion that was sent almost 3 months ago?
I'm not sure. I can't speak for anybody else.
So when something's entered into the record, it's not read into the record or entered that it has been read or anything to that effect?
No. When we receive something, we enter it in the system as the date that it was arrived and clocked in. There is no record of who has looked at it.
There's no record of who has looked at it?
Yeah, I mean, I can't say who's pulled this file and reviewed this, because I don't know.
So if I drove like 3 hours from where I live to come up there and talk to somebody, there's nobody that could give me any more information than that? If I did a certified copy of the case file or any of that, I couldn't get any more information than that?
All we can give you is what's in the file, and that's the motion and the complaint.
Wow. So, well, I understand you had personnel turnover. I get that. Everybody goes through that. That's unfortunate sometimes. But, all right. Well, thank you very much for.
Did you want to leave your number so she can call you back?
Well, I've left it already and nobody's called me back. I have a feeling I'm being ignored here. So, I'm not real. I'm not thinking that somebody really wants to call me back and give me any information, because when I do call back, I don't get any information and I'm just given a bunch of excuses.
Well, I can't speak for the clerk. You know, she was the last one that spoke to you, told you she'd review your motion. I can't speak for her, and she's not here anymore. All I can do is relay this to the new clerk.
Okay, I understand. And this, this doesn't come down on you. Trust me, it doesn't. I get it. I know how these things work. But I appreciate you taking the time and talking to me and trying to get some information for me. That is very much appreciated.
You're welcome.
And I hope you have a nice day. And if I don't talk to you before Christmas, I want you to enjoy your Christmas and your New Year.
Same to you.
Take care, dear.
Okay, you
Bye.
too.
So that's where we're at. That conversation took place on the 12th of December, and I sent it. They received my motion on the 15th of October. So almost 3 months. In fact, tomorrow will be 3 months. But anyway, that's where I'm at. If any more updates come about, I will be sure to pass them along so everybody can follow along and understand how this works and how they work against we the people. Take care.